Hello everyone. We would like to thank you all for allowing us to inform you guys about employee discipline and the do's and don'ts. Our team members are Eric Peña, Alejandra Martinez, Yamini Patel, and Mary Indosiga. History of Employment at Will Doctrine. The foundation doctrine was first laid by a judge in the state of Tennessee. The judge stated that all may dismiss their employees at will, be they many or few, for good cause, for no cause, or even for cause morally wrong, without being thereby guilty of legal wrong. With this statement, the judge was able to lay the foundation for the common law known as the employee at will doctrine. Even though this doctrine was stated and followed for many years, it was not confirmed until the year 2000 by a California court which stated that an employer may terminate its employees at will, for any or no reason. The employer may act peremptorily, arbitrarily, or inconstantly without providing specific protections such as warning, fair procedures, objective evaluation, or preferential reassignment. The mere existence of an employment relationship affords no expectation. It is protectable by law that employees will continue or will end only on certain conditions, unless the parties have actually adopted such terms. We now understand that the employee at will doctrine means that an employee can leave a job whenever they want for any reason, and the employer can terminate an employee when they want without notice or cause. The employee at will doctrine was made in order to prevent wrongful termination and employment lawsuits between the employee and the employer. The Wagner Act of 1935. The Wagner Act of 1935 helped shape management's disciplinary policies in which prohibited the act of discriminatory discipline of employees due to their union activities and/or membership. Due to this, the NLRB, also known as the National Labor Relations Board, was created for enforcement purposes. This was the first time that management could be legally held accountable for employee discipline in the workplace. After the NLRB's decision, nearly all existing collective bargain agreements had to have both a provision regulating employee discipline as well as a grievance procedure. This resulted in managerial policies being greatly influenced by the growth and development of labor arbitration. The arbitrators had three broad powers on discipline. Broad power number 1 was to determine what constitutes just cause for discipline. Broad power number 2 was to establish standards of proof of evidence. And broad power number 3 was to review and modify or eliminate the penalty imposed by management when warranted. Employment at will doctrine. In 2014, more than 88% of the United States workforce are not offered the protection of a union contract or collective bargain grievance arbitration procedure. In other words, around 116 million workers were at will, in which they could be discharged by their employer at whatever time. The public policy exception to the employment at will doctrine states that an employee is wrongfully discharged if the discharge is inconsistent with an explicit or well-established public policy of state. An employer may not discharge an employee for filing a workers' compensation claim after being injured on the job. However, not all states recognize the same number or type of public policy exception. The implied contract exception occurs when an employer and employee form an implied contract. An employer may not fire an employee in a situation in which an implied contract has been formed between both parties. A written instrument that explains the employment relationship simply will not exist. After the implied contract has been established, terminations are prohibited. Only 42 states have recognized the implied contract exception. The Covenant of Good Faith and Fair Dealing states that an employer personnel decisions are subject to a just cause standard. This prohibits termination that is made in bad faith or that is motivated in any way by malice. Only 22 states have recognized the Covenant of Good Faith and Fair Dealing. Thank you very much for your time, and I would like to pass it on to Yamini.
Present-day significance of employee discipline. First-line supervisors are the first persons to become involved in investigations and disciplinary actions. There are two different types of discharges. It upholds management discharge decision, which means that when you have an uphold discharge decision, it is the decision of the first-line supervisor to either terminate the employee or to suspend them. And the second type of discharge we have is reinstating an employee. When you have a reinstatement of an employee, there are disciplinary actions that carry out significance and are affected to the employee with reduced pay, which means that they are most likely to get paid, but they won't get paid their full salary. This will cause the employee to have back pay, which means that the employee will not be receiving the full amount of payments for their reinstatement of the company bringing them back. Discipline for just cause and discipline's legitimate purpose. As part of being the 7 tests definition, there are 3 different components in defining just cause. The first one being industrial due process, which means when that employers are expected to conduct a timely, full, and fair investigation where all the evidence is considered before imposing discipline. The second one is industrial equal protection, which means that it compares with prior similar instances of disciplinary actions. And the last definition for just cause is individualized treatment, which is the arbitrator's consideration such factors as the employee's prior discipline, job performance record, length of seniority, and work history in their decision. Degree of proof in disciplinary cases. Arbitrators have 3 different levels of proof. First one being preponderance of evidence, which is when you have testimony and evidence that is adequate to overcome opposing presumptions and evidence. 2, clearing and convincing evidence is when you have the truth of the facts that are asserted in high probable causes. And 3, you have beyond a reasonable doubt, which is proof when you have extraordinarily high and should not be used in arbitration because of the level of proof used in the NLRB and unemployment insurance cases. They do not require the proof of beyond a reasonable doubt. And here is Eric with a little bit more on arbitration.
Thank you for that. Labor relations and actions. Arbitrator's main purpose is to get an employee a fair trial and find success in the outcome of his or her employment. Arbitrators find as much evidence as possible to help the employee's case. Arbitrators find witnesses of the scene of the incident. Arbitrators interpret items so that the employee could save face. Arbitrators are another form of an employee's personal attorney or assistant. They assist the employee in any way possible for the better performance of his or her job. They assist the employer with any questions they may have, any answers, any disputes, anything to help the employee perform better in his employment success. Labor relations in action involving employee discipline and social media. Managers must be clear in setting rules and guidelines. They must also invoke violations and penalties for all rules being made. Equality must also be held at high regard. Companies have also implemented a price list to their organizational disciplinary procedures. A price list is a set of specific rules and furnishes uniform penalties for all single and repeated offenses. Under social media, be mindful of what you post online. Employees look on candidates' social media for interviews, background checks, investigation, and allegations. Before an interview, this is a great way for a potential employer to look up a future employee's background and see how they present themselves outside of work presently. Working for the city of San Antonio, there has been many times when a complaint has been made about a city worker of unethical use of company hours. Thereafter, an investigation is made where an investigation goes underway with the employee and he has been looked over for through the social media and other outlets that he promotes. Also, be mindful of your company's culture. Like me personally, working for the city of San Antonio, they strongly promote professionalism and encourage all employees to post respectfully and to stir away from any vulgar pictures, any drug related pictures, any partying, anything that could be frowned upon from the public.
Thank you, Eric. Next, we will talk about the effect of work rules on discipline. In most disciplinary situations, particularly those cases that are somewhat common, management is on the weak grounds with the arbiter when it does not establish work rules. Furthermore, written work rules must be reasonable, clear, and state the consequences of the violation. When talking about the effect of work rules on discipline, we have first some complication regarding rule fairness that can occur when employee is disciplined for off-the-job behavior. But in this case, discipline will only happen if management establishes that it affects the employer. The clarity of a work rules is also an important issue because employees cannot adequately perform or correct behavior if they do not know what is expected. In fact, management officials can create a problem when they discipline employees for infractions of a vague or confusing work rules, such as, for example, discharge for gambling on company premises or even falsifying an employment application. Next, we have the existence of work rules which carries the implicit, if not explicit, obligation for management to inform its employee of the rules and the consequences of their violation. Sometimes, an employee disciplined for violating a rule can argue that he or she was unaware of the work rule. Management then usually has the difficult task of proving otherwise. Finally, management must regulate the rules consistently for the employees who violate the rules under similar circumstances. Management will likely have its disciplinary action reduced or even eliminated by the arbiter if they establish that the employer was inconsistent in enforcing the rule for the same misconduct on previous occasion, or gave different penalties to employees who were involved in the misconduct. In the next slide, we will have a short video that will be explaining progressive discipline in the workplace.
Progressive discipline in the workplace is a process for dealing with employees' job performance in a systematic way. When performance problems arise, a policy of progressive discipline addresses those problems with increasing formality, often starting with a warning, meaningful coaching to help the employee correct the problem, and escalating discipline if the employee does not improve his or her performance. Ultimately, the disciplinary action may result in suspension and/or termination from employment. Because progressive discipline policies provide ample opportunity for an employee to correct performance problems and supplies the employer with substantial documentation of uncorrected performance problems, these processes may make it easier for an employer to defend against an unlawful termination lawsuit. For more information on progressive discipline, contact an attorney in your area today.
Thank you, Maria. Now we will be discussing disciplinary penalty and mitigating circumstances. The book defines disciplinary penalty as actions imposed directly upon the discovery of an offense. When this occurs, the person that is accused is asked to provide an explanation for the offense. Some types of disciplinary actions companies enforce are progressive, oral, written, suspension, and termination. Progressive is used to intensify the penalty of the offense that is becoming a repeated problem or an issue. Oral warning, aka also known as a reprimand, is a verbal warning to correct the offense in an informal manner. A written warning is the next step in the progressive discipline. It then becomes more serious because it summarizes all the previous efforts in correcting the employee's behaviors. Suspension is a temporary layoff without pay to the employee because all efforts prior to the matter have not been resolved. Termination is when the company has exhausted all outlets for the employee and is then forced to release the employee of his or her duties from the company. Some companies now require an employee to take off a day without pay, also known as a timeout, to think about what his or her employment situation and to determine whether he or she is willing to return back to work and commit to being a productive worker. Working for the city, we have a point system that ranges from 1 to 32, with as little as 1 being equivalent for a tardy, to 16 being a write-up, and 28 being suspension. Now for mitigating circumstances are factors that lessen the security or capability of a criminal act. Some examples include age, remorsefulness of the defendant, lack of supervisor involvement, long term of good working record, unsafe practices in the workplace, arbitrator specialized tactics. Some of the specialized arbitrational tactics arbitrators use are due process, just cause, and equal protection. Due process meaning that the defendant was not issued enough time to have a thorough investigation of his or her case. Just cause meaning that management must have proper reasoning for issuing penalties upon an employee or just cause. And lastly, equal protection means everyone who is trialed from their employer must have a fair trial, and no favoritism should be released to any other staff members of the company. Now we will be discussing possible collisions with discharge decisions. Possible collisions include disgruntled employees, disgruntled management, the filement of a suit, the involvement from the union, including arbitration, bad publicity, company time, and company money loss. Possible collisions can be avoided if management and proper procedures are put into place for successful operation. To add to possible collisions, we will now be discussing public policy and due process. Public policy can be defined as a system of laws, regulated measures, courses of action, and funding priorities concerning a given topic. In other words, rules made to keep an order in a process. While due process is a requirement that legal matters be resolved according to established rules and principles. This is to keep the fair treatment of humanity. And the possible collisions include employees forming a strike, unemployment, union involvement, and legalities.
Weingarten Rights Act. Weingarten Rights Act definition means when an employee has the right to union representation during an investigatory interview. The rights established by the Supreme Court in 1975 in the case of J. Weingart Incorporated must be claimed by the employee. The supervisor has no obligation to inform an employee that she or he is entitled to union representation. The employee must make a clear request for union representation before or during the interview. The employee can't be punished for making this request. After the employee makes the request, the supervisor has three options. Either grant the request, deny the request, or give the employee a choice of having the interview without representation or ending the interview. If the supervisor denies the request and continues to ask questions, this is an unfair labor practice, and the employee has a right to refuse the answer. Employees cannot be disciplined for such refusal, but it is required to sit there until the supervisor terminates the interview. Leaving before this happens to constitute punishable insubordination. You are not required to be merely silent witness. You have the right to be informed by the supervisor, take the employee aside for a private conference before questioning begins, speak during the interview, request the supervisor to clarify a question, give the employee advice on how to answer a question, provide additional information to the supervisor at the ending of the question. You do not have the right to tell the employee not to answer. Obviously, give false answers.